Right. Sound and vision all right for Lord Justice Newey?
They now seem to be. I don't know what happened, I'm afraid.
All right. You're quite faint in terms of the voice. I don't know if you can turn up your microphone a bit.
I'm afraid that seems to be the maximum possible.
That's much better. Right, Mr. Williamson.
Yes, my Lord, welcome back to Lord Justice Newey.
Thank you.
My lady, I don't know to what extent Lord Justice Newey heard this exchange, but you were putting to me that effectively para 108 at core 224 got the horse before the cart or whatever. And in my submission, that is not a fair criticism of the Upper Tribunal. They are seeking to discern objectively the common intention of the parties. They have made a number of findings which are essentially matters, I would accept, of inference from the circumstances, and they are now seeking to test those findings against the contention put forward by HMRC that the changes are so substantial as to call that common intention into question. And that in my submission, on any view of the Morris and Barron line of cases, is an appropriate exercise to undertake. They undertake it and they conclude at 109 as a matter of fact that the changes are not substantial.
Yeah.
So we say to put it in the vernacular that HMRC by this point in the judgment are snookered either way, because if it's simply a matter per Plavin of looking at the common intention and one not really concerned with how far the changes go, they've reached a conclusion. If some of the other speeches in Morris and Barron, we're carrying out this before and after exercise that my Lord mentioned yesterday, they've done it and they've concluded that there's no substantial change as a matter of fact. Now, that takes me to the facts, and I'm afraid before I go to the relevant documents and the findings, it is necessary to make this point, procedural point. It is important to note what HMRC argued before the Upper Tribunal, and indeed argued until yesterday. They did not argue that change orders 2 and 3 lacked contractual effect. On the contrary, their position throughout was that they went so far that they rescinded the golden contract and or created a new contract. And if we look at the decision which we're in, if you could go back to page 218, sorry, 219, sorry. So paragraph 85, they have rejected our clause 12 argument, and then they say this: it necessarily follows that the change orders resulted in a variation to the terms on which the parties contracted. We turn therefore to consider whether, as we submit, that was an amendment, or as HMRC submit, it resulted in rescission. Then they refer at paragraph 86 to the section, which we'll come back to. The question, they say at the top of the next page, was to be answered by reference to the common law principles which determine whether two parties to a contract had, by reason of a subsequent agreement between them, rescinded that contract. And then if we could go to paragraph 111 on page 225. Even if the effect of the change orders was not to rescind, HMRC argued that those change orders created a new contract that stood separate from the golden contract. Now, that was the judgment. That was the understanding of the Upper Tribunal. And then at tab 5.
5.
5, yes. Page 153, paragraph 52. So this is HMRC's skeleton argument to this court. Paragraph 52. In the alternative to their submissions that the change orders were rescissionary variations, HMRC, so that first phrase accepts that the change orders were of contractual effect. HMRC contended that the change orders created a new contract that stood separate from the golden contract, which is exactly what the Upper Tribunal was referring to. Then over the page at 154, had the UT applied the proper approach, paragraph 55, it would have been compelled to find that the contract entered into under the change orders was a new contract, even if not rescissionary, despite having been erroneously labelled. So, for example, my Lord Justice Lewison put to me yesterday, well, where was the agreement arising out of the change orders? Where is the finding from that point? And it's, in my submission, somewhat unfair to criticise the Upper Tribunal on that basis, because it was common ground between the parties that those change orders, even if they didn't take effect under Clause 12, nonetheless had contractual effect. Now, why this is relevant is because during the course of oral submissions yesterday, HMRC raised a number of new factual points which were not foreshadowed below or in the grounds of appeal or in their skeleton argument, and which were quite contrary to how the case was put before the Upper Tribunal. So on that point about no agreement, no contractual agreement arising out of the change orders, which appeared to be submitted yesterday, it was said, well, there was no agreement, and or the parties mistakenly proceeded on the basis that Clause 12 applied, and so were never ad idem. Now, as I've already submitted, those points were new, contrary to how the matter was put before the Upper Tribunal, contrary to how the matter was put in the skeleton argument to this court. And we are prejudiced by these changes of case, because if they had been raised before the tribunal, we would have led evidence to show the following things. First of all, the change orders were preceded by negotiations between development and contractor, which resulted in the agreed figure of 54 million, or as the case may be. Secondly, that payment was itself preceded by the issue of an invoice in that amount. And in the little file which I handed up this morning, if the court could go to tab 2, and for Lord Justice Newey's benefit, this is the invoice of 1st April 2011.
Yeah.
So this is an invoice raised on the 1st of April, order said to be construction sums due under the contract of February 06 and pursuant to change order 2 in full and final settlement. And
I infer from the number 4242 that it was that this document was before the Upper Tribunal.
My Lord, I think that's right. We've been having to move with some speed.
Yeah.
Overnight.
No, I follow.
I'll have that checked, and if it wasn't, I will let your Lordship know. And the third thing that we would have led evidence to show was that there was no relevant mistake between the parties, which is obviously a question of fact. And in any event, we would submit this is a completely artificial argument, because the change orders are recording what had been agreed between developer and contractor, and or amounted to an offer which the contractor accepted by constructing DC2 and DC3.
Well, that was the analysis you put forward yesterday.
Yes, yes. By raising that invoice,
Accepting the payment and building the building.
Exactly, yeah.
Yeah.
Now, while we're on the subject of new factual arguments, and my Lord Justice Lewison referred to this a moment ago, it also seemed to be argued yesterday that by giving the notice to proceed for Works Order 1, the developer had somehow shot its bolt and could not then issue further instructions in 2011. Now, again, that's a new point, never raised previously, and quite contrary to the case which was run, as we've seen.
But that's a matter of contractual analysis, isn't it?
Well, it's a matter of the history, which I'm about to take you to, if I may. If we could go to, first of all, if we go to the judgment, Core 9, page 214.
Yeah.
So this is really just by way of recap. Paras 61 and 62, the court will recall the reference to variation agreements 1 and 2, which changed the way in which the menu was to be approached. And then the issue of change order number 1, and that is in the little bundle I've just given you, that is the last document, tab 4. So this is dated November 09. It refers to works options 1 and 3, which were both in play because of the earlier variation agreement. And then the critical passage is the last sentence on the first page. Further change orders may be issued in respect of the buildings within works option 3 or otherwise in accordance with contract, to the extent that they relate to that part of the land not affected by this change order.
But if works option 1 only related to a particular part of the land, which it did, and the buildings couldn't be built on that land, then how can that be part of the land not affected by this change order?
I'm sorry, Mary, I've just had a bundle disaster.
Sorry.
The ladyship was asking me that question.
I remember works option 1 related to a particular site on the land, and the subject matter of this variation of this change order was to build a building on that site and that site alone. There wasn't room for any other building on it. So looking at that last paragraph, to the extent that they relate to that part of the land not affected by this change order, you can't, it seems to me, give further change orders in relation to works option 1 under the words or otherwise, to the extent that they relate to part of the land which falls outside of the catchment area for works option 1.
Well,
I hope I put that clearly.
no, I understand the question. I'm just struggling to understand, as it were, why not?
Well, because of the plain language of the clause. What this envisages is that you might be able to issue further change orders in relation to part of the land that's not affected by this change order. But the words or otherwise are meaningless, aren't they, in relation to works option 1? You've exhausted it. That option's been done and dusted.
Well, that in my submission is a question of fact, which was never gone into for the reasons I've explained. We're in the realms of seeking to reconstruct factual findings which were never live before the Upper Tribunal. And in my submission, those words open the door to the instruction of further works under the carapace of either works option 3 or works option 1. So, my lady, having dealt with some but not all of the new points which arose yesterday, can I come back to how the case was put before the Upper Tribunal, and could we first look at the change order itself?
Before we do, and I'm sorry to take you out of your course, but just in terms of the chronology, you took us to paragraphs 61 and 62 of the judgment, of the decision of the Upper Tribunal.
Yes.
And there's a finding in paragraph 62 that following the issue of change order 1, DC1 was constructed. What we don't have is a date for the completion of that construction. Is it to be found anywhere in the bundles or in the Tribunal's finding? And if so, what is it? I mean, I'm assuming that it was constructed before the 1st of April 2011, but I may be wrong about that, and I'd like to know.
My lady, rather than seeking to find my way through the documents,
Yes.
I'll
Perhaps those behind
those
you
behind
can
me
make
may
inquiries
know
and
the
find
answer to
out.
that question.
Thank you.
we were going to go. I was going to go to the judgment. Just before we do that, could we have a look at the change order itself, which is at the core supplementary bundle tab 3.
Tab
3.
3.
Now, the spectacles through which we are looking at these documents is, in my submission, to seek to ascertain what objectively is the intention of the parties. That, I think, is uncontroversial. And I've made the following points about these documents. One, this is said to be a notice to proceed under the existing contract. 2, it is referable to works option number 1 under the existing contract. 3, it is given, or at least purports to be given, under clause 12 of that contract, the JCT terms. 4, if you look at page 75, the way this document works is that the developer in part 1 requests a change, and then it is for the contractor in part 2 to say how it wishes to respond to that request. And the request is to add, as necessary to the employer's requirements for works options 1. Works option 1 so as to provide a DC2. Fifthly, there's no suggestion in these documents, save as to price, that there is any renegotiation of terms. 6, it is the same parties, and 7, it is at least implicitly all pursuant to the JCT term subject to the bespoke amendments which you were taken to yesterday. And if we could go back to page 74, another point which arose yesterday for the first time was the suggestion that this instruction was only to proceed with the shell and core works and not the fit-out works. That's not right. The obligation is to do everything. The price is for everything, but the works are only proceeding in the first instance for obvious reasons with shell and core, and we get that from the penultimate sentence on page 74.
So you would say commissioning includes fit out?
Yeah. Now, pausing there, if one looks at these documents, in my submission, this is a very odd way of either tearing up the existing contract or entering into a fresh contract. Now, if we can just put that away for a moment and then look at what the Upper Tribunal found, back to the core at tab 9. First of all, page 202, paragraph 8, the first sentence, that the developer and the contractor were at all material times special purpose companies within the same group of companies. Then, if we could go to page 208, Para 33, in 2006, Atmel realised that the 10 years was about to expire, so they established the two special purpose companies. They entered into the golden contract, and then the golden contract was therefore entered into the day before the enterprise zone at the site expired, and formed part of arrangements that both the developer and contractor hoped, in other words, seeking to get into the ballpark whereby would ensure that EZAs could still be claimed. And then we've already looked at paragraphs. We just remind ourselves at page 223 and 224, we've already looked at paragraphs 105 to 109. And in my submission, the finding at 107 is, in my submission, an inference which the Upper Tribunal was entitled to draw from the documents we've looked at, coupled with the facts which they have found. So, pausing there, just to complete what I wanted to say about rescission. Obviously, rescission is a drastic option, the complete discharge of an existing contract, so that it cannot be revived. And we would submit that if you look at those documents in conjunction with the findings of the Upper Tribunal, inferences drawn by the Upper Tribunal, it simply was not the case that the developer and the contractor intended in 2011 to rescind the golden contract. And then, so far as the new contract point is concerned, to a large extent, this is another way of putting the same point on the part of the LLC. And we would submit that for the reasons already canvassed, the parties did not objectively intend to create a new contract. They intended to leave the existing contract in place but varied as to its terms. I've made the point that we don't accept there's such a thing as a fundamental variation which the parties cannot make.
But the ultimate question that we've got to decide, I think, correct me if this is wrong, is whether this is expenditure incurred under a contract made within the 10-year period.
Yes.
And that must mean it's the same contract, mustn't it? However, leaving aside what makes it different, but it's got to be the same contract.
Yes, well, putting it another way, there's only one candidate, and that's the golden contract.
Yeah.
Yes.
So in the end, what we've got to decide is, was the contract the same contract as the golden contract? Whether you talk about rescission or new contract doesn't really matter.
No.
Is it the same contract?
Yes. So just in terms of the changes, it is a different description of building, which is agreed in 2011, but it is still an industrial building. It is a slightly different site, but it is adjacent and still within the enterprise zone. It is a different contract sum, but that is what the parties agreed. And just to see, as it were, where we started from, could we just look at works option 1 for a moment? That's in the supplementary bundle B at tab 21.
Oh, the supplementary bundle, not the core supplementary.
Yes, the full volume supplementary bundle.
Yes.
The front page refers to an 8-inch fab semiconductor manufacturing facility. And then if we could go to page 765, para 131. The proposed works are the location is given. The works comprise the design and construction of an 8-inch fab semiconductor manufacturing facility to provide a second module building and a second utility building. And then there's various technical information. And if you go to page 809, I'm afraid it's not a very high quality photocopy. There's a plan there, and the new buildings there is more. The short point is there is more than one new building, which is to be constructed under works option 1. So we've got building 34, which is a module 2 building, building 65, which is a utility building, and building 66, which is a gatehouse.
Where do we find those on the plan?
Well, my lord, I
do we
feared
not?
you might ask me that question. The answer is that this photocopy is not sufficiently good, but if it would assist, we will.
This what?
If it would assist, we will seek to obtain a better, clearer copy, which we can show.
I think if it's of significance, it probably would assist.
Yeah,
The numbers are going to be somewhere on this plan.
they are. Yeah.
Right.
My lord, subject to a clearer plan, the broad point is that within the site as a whole, a number of buildings were to be built under works option 1, and what was eventually agreed to be done in 2011 is on the same overall site, same parties, the same contract terms, the same enterprise zone, the same type of industrial building, albeit of a different description. So, in summary, we would say that there are alterations in 2011, but they do not come close to satisfying the Haldane test of being sweeping alterations, even if that is relevant.
Yeah, and anyway, you say presumably this is a question of degree for the Upper Tribunal. They carried out the correct evaluation. That's a question of fact, and
Yes.
Unless there's an Edwards and Bairstow type challenge, that's it.
Yes, my Lord, that's exactly right. So what I've endeavoured to submit this morning is that they've directed themselves correctly as to the law. They have considered the facts at paragraph 108 and they have reached a conclusion,
Yep.
which other tribunals might have reached a different factual conclusion, but that's irrelevant. Now, just on that point, Manane and Friend had a point yesterday, which is in the skeleton, about burden of proof, and this is the point about the missing employers' requirements, the draft employers' requirements, which are referred to in the change orders. Now, that point was raised before the Upper Tribunal, and they dealt with it at page 215. It's paragraph 67 to 69, and they essentially say that there's no need to consider that issue. Now, the position is the draft employers' requirements referenced in the instructions have been lost for whatever reason, but HMRC and the tribunal were provided, which we looked at yesterday, with the employer's requirements issued by the contractor to its subcontractor. It is obviously highly likely to be the case that the same employer's requirements went all the way down the contractual chain. As we've already seen, the contractor was a special purpose vehicle. It was always going to subcontract the whole of the works, and it was very unlikely to ask its subcontractors to do something different than it had itself been asked to do. So my lords and my lady, the final point I wanted to cover in relation to the facts was another new argument raised by HMRC, which relates to the SDA. That has the merit that it was raised as long ago as the 16th of September of this year. However, we are still prejudiced by it because it was never raised before the Upper Tribunal and never gone into. And just to see what then happened after the judgment of the Upper Tribunal, if we could go in core bundle to tab 4. Page 105. So those are the grounds of appeal. They're very scant.
Yeah.
They're to be read with the skeleton argument. But the skeleton argument does not submit that the works were actually carried out pursuant to the SDA. Lady Justice Asplin then gave permission to appeal, which we find at tab 11. under the number 0636 and 0639 are our numbers. She says the ground has a real prospect of success. It is arguable that the Upper Tribunal applied the wrong test when determining whether the Golden Contract had been varied or rescinded, and failed to consider all relevant documentation and erred in its application of the tests of the facts. Accordingly, it's arguable that they erred under section 298. So those are the matters raised, those are the matters for which permission has been given, but it goes beyond that, because if we look at the agreed issues, which I fear we're going to have to look at again in a moment, but just on this point, which is same bundle, tab 9, page 206. There are three sub-issues agreed to issue 1, but there is no sub-issue to the effect that the works were carried out under the SDA. And this point of prejudice is a real one, because if this point had been raised earlier, it could have been the subject of a further or an amended application for judicial review. And the court will recall yesterday you were taken to the correspondence, which is at page 276 in the same tab. Para 320 cites Mr. Watson's letter for the industry body, and he says that his understanding is that this is a 4-step process. Step 1, it's agreed to begin work so that the lump sum becomes immediately payable under the terms of the Golden Contract. Step 2, sum is paid. The developer is now entitled to have the building constructed for no further consideration. Step 3, the developer transfers its interest in land. And that, the effect of the correspondence was that HMRC were not demurring from that understanding in the industry as to how the arrangements worked. Now, so far as the SDA itself is concerned, that is at Core Supplementary Bundle tab 4. If we could pick it up at page 79. Just to note two things. First of all, this is entered into on the 4th of April, and it's entered into by 5 parties. The developer and the contractor, here referred to as the principal contractor, are the first 2, but the other 3 parties are not parties to the Golden Contract. And then, if we go to page 85, the principal contract is defined as the Golden Contract. And then paragraph 2.5 on page 88 recites that the developer has, prior to the date hereof, paid to the contractor the 54 million, which you've seen being the total amount due and owing pursuant to the principal contract. And that had in fact happened, and that the reference for that is paras 38 and 39 of the judgment, Core Bundle 9, page 209. And then clause 3 is step 3, I think it is, which is the assignment of the benefit of the rights under the principal contract. And of course, on the known friends case, what was being assigned was worthless because the principal contract either had been rescinded or certainly was not the arrangement under which the building works were actually to be carried out. So I'm going to move on now, I think probably quite briefly, to the two-stage approach. That's my third submission. And here I am in danger of seeking to persuade grandmothers to suck their own eggs, because the law is, if I may say so, without undue sycophancy, correctly set out in Lewis on the interpretation of contracts, which is at Authorities Bundle C, tab 42. So the overall principle is at page 954 in bold. The legal effect of a written contract may involve a two-stage process. First, to ascertain what rights and obligations the contract creates, and second, to determine what kind of contract has been made. And then there's a citation of the famous passage from Street and Alford by Lord Justice Newey referred to yesterday, Agnew, and other cases. And in my submission, the bottom line on this line of cases is what Lord Walker said, which is extracted at 4.19 on 956. First of all, the learned author comments, in each case there is a public interest which overrides unrestrained freedom of contract, namely to assure that the substantive law is properly applied. And this is a public interest question to prevent unscrupulous landlords or unscrupulous companies from doing down those who are entitled to the benefit of the Rent Tax or the benefit of protection in insolvency and so on. Now, unless you wish me to do so, I don't think it's necessary to go into the cases which are cited here. I think the principles are well enough known. And in my submission, that line of cases with which we have no quarrel has no application to the question, the plevin question, which is there an intention to rescind or to carry on with the contract, effectively? My Lord Justice Lewison referred the parties yesterday to the Australian case of Telstra, and that's the first enclosure in your file. Now, the facts are quite complex, and I can't pretend to be fully on top of them in the time that I've had to look at this. But I think the only paragraph we need to look at is paragraph 132 on page 52. And I think this paragraph needs to be prefaced with something of a health warning, in the sense that when the judge is referring to variation, I think he means rescission. He's not talking, as I read it, about a variation which changes the obligations, but insufficiently to bring into play Morrison-Barron principles. Now, the first thing he says is the question whether there has been a quotes variation, which I take to mean rescission, is dependent on the intention of the parties objectively determined from the words of the contract. Regard must be had to the nature and extent of any differences. Well, that we would submit is exactly the approach the Upper Tribunal took. Then he says it doesn't follow that because the parties have asserted that their mutual intention was not to vary a contract, that what is otherwise a variation is converted into a non-variation. I think what he's meaning there is to say that if, as a matter of law and fact, you have, objectively speaking, done acts which rescind your existing contract, but you then put a post-it note on top of it saying this is a variation, not a rescission, that won't get you home. I think that's
or
what
if
he's
you
saying.
put it, or if you put it in the contract itself.
Yeah, as in this case.
Yeah.
There were terms, I said, it wasn't varied.
And then he deals with, I think, a point which is really factual. Then he says, of course, an express statement of intention is an important consideration when interpreting a contract. But if the changes are of such a nature and degree to give rise to it, that's really the point I've made. So we are entitled to...
I wonder, I'm sorry, while we're at it, you could just look at paragraph 134 as well, which I think has got some relevant things about it.
My own friend invites you to read paragraph 134. So, in my estimation, all we get from that case, insofar as the court takes it into account at all, is that the question depends on the intention of the parties objectively determined, which we know. Secondly, express statements as to intention are important. But thirdly, if on objective analysis an agreed change is in truth rescissionary or creates a new contract, the fact the parties label it as a variation will not help them. So that's all I was going to say about the two-stage test. And I was then going to go on to section 298, and it might be helpful just to have that out. That's Authorities Bundle A, tab 4, page 46. Now, I'll come to the concession in a moment, but concession below, that's to say. My own friend seemed to suggest yesterday that there is some ambiguity in this section, and therefore, by virtue of the principle enunciated by Mr. Justice Sales as he then was, that it is open to the court to look back at precedent legislation to work out which of the rival constructions is to be preferred. I think that's how he put it. In my submission, there is no ambiguity in the section. You have to consider, or a person reading this section has to consider three questions. First of all, has there been expenditure on the construction of a building on a site in an enterprise zone? To which the answer in this case is undoubtedly yes. If that question is yes, then the next question is, did that occur?
Well, not sure that it is yes, put in that way. There was, in this case, as I understand it, expenditure on the construction of an industrial building which was in an enterprise zone. But by the time that the expenditure was incurred, it was no longer in an enterprise zone, was it?
Well, that's right, but that point is taken up, if I may say so, by the next question.
Well, quite. But if you're going through the questions to be asked, it's a slightly different question under the contract bit. If you're looking at what you might call a plain vanilla case, the building has got to be in the enterprise zone when the expenditure is incurred, hasn't it?
Yes, but what I was my second proposed question was, did that occur within the 20-year time limit? And we would submit the answer to that question is obviously yes. The building has been built in an enterprise zone within 20 years. So
within 20 years of what?
Within 20 years of the site first being included in the zone. Those are the words at the end of the subparagraph B.
Yeah.
So the live question, and indeed the question which the Upper Tribunal was asked to decide, is whether all of that happened under a contract entered into within the 10 years or under some other contractual arrangement.
Yeah.
So, in answer to my lord, in my submission, that there is no ambiguity here. It's all perfectly clear and simple. Now, I was going to deal next with the concession. And can we just first see how that is dealt with by the Upper Tribunal? So we can put aside this section for the time being. So that's back to the core bundle tab 9. So first of all, just to remind ourselves of the agreed issues at page 206, paragraph 27. The only relevant issue was sub-issue 3, was the construction of the buildings in question under the Golden Contract. And then, just to see how the Upper Tribunal understood that question, para 86 on page 219 They say the essential question is whether the expenditure on the data centres was incurred under a contract entered into within 10 years. That was indeed the essential question. In response to questions from the tribunal, the parties indicated that they were broadly in agreement that the phrase in section 298 was not to be given any particular meaning according to principles of statutory interpretation by reason of its statutory context. Instead, the question was to be answered by reference to common law principles, which determine whether two parties to a contract had, by reason of a subsequent agreement, rescinded the contract. And then paragraph 101 on page 222. They're discussing the Shell case here, and they refer to a finding by the special commissioners, and they then say this: we pause to note that the agreement between the parties that the issue in this case is to be determined by reference to the law of contract and does not turn on any issue of statutory interpretation precludes HMRC from running an argument along the lines which succeeded in Shell. And then finally, page 227. They're dealing here with the uncertainty point, which I think has now fallen away. Para 120, they say it's unnecessary for us to decide whether an argument about the proper construction of section 298 was contrary to the agreement between the parties that issue 1 as a whole was concerned only with the application of common law contractual principles. For completeness, however, we would have found that it was not open to HMRC to do so. Now, how did the Upper Tribunal come to this understanding? Well, it did so by reference to exchanges between counsel, which culminated in an email which you will find at the same bundle, tab 5, page 157.
Sorry, could you please give me the page number?
Yes, I'm sorry, it's tab 5, page 157.
Thank you.
Appendix A, yeah?
Yes, so this is an appendix to one of the HMRC skeletons. The actual email is somewhere in the bundle, but it's the typeface is so small it's impossible to read. So this is an exchange which is going on during the course of the hearing, and Learning Friends for HMRC write as follows: over the course of discussions yesterday, it became apparent that the claimant's concern with the current draft of issue 1.3 was that the use of the term under in issue 1.3 would permit HMRC to assert that expenditure, etc., might fall outside the scope of section 298, even in circumstances in which the expenditure is incurred under the golden contract. And then they noted a concern that we were seeking to argue that the section was wider than the law of contract and principles of contractual construction. HMRC can confirm the question of whether or not expenditure on the construction of the buildings in question was under the golden contract falls to be considered in the context of the law of contract and principles of contractual construction. Please confirm the use of under accordingly. So in our submission, the Upper Tribunal quite correctly understood the position as it had been agreed between the parties, as it had been conceded between the parties. And I just note in passing that the learned friend did not refer to the concession at all yesterday, but he certainly did not seek to withdraw it.
I don't really understand this point, I have to say. The tribunal's job, and indeed our job, is to apply the law as we see it. And what the parties agree the law to be, or what they concede the law to be, doesn't matter. We all swear oaths to apply the law, and that's what we do.
Well, I'm not seeking to invite your lordship to abandon your judicial oath, but in my submission, well, there are a number of points. First of all, the alleged ambiguity to which Malone and Friend was referring.
Well, that's a different point. Now, you're relying on the concession here. Now, I quite understand that if the parties agree the facts, then that's the tribunal or the court doesn't go behind that. The court shouldn't be investigating facts on its own. But if it's a question of law, whether it's interpretation of a contract, about which there's plenty of authority that the court's not bound by concessions, or a statute, I would have thought the court's got to apply the statute correctly insofar as it can. I think the parties can't preclude it from taking a view about what the statute means.
Well, in relation to the ambiguity point, I was staying on your lordship's question, right, but seeking to answer it in a slightly different way, right, because in my submission, it's worthy of remark, at least, that if there was indeed the ambiguity which is now alleged in the section, that this concession was made and the hearing proceeded as it did.
All right.
Certainly not a very obvious ambiguity, and we submit there is no ambiguity.
Well, that I understand.
Yes, and while I'm on that point, Malone and Friend sought to take you back to the, I think, 1980 Act, which brought this regime into force. But in my submission, we can look at it if necessary, but the wording of the earlier statute, even if there is an ambiguity, doesn't assist in relation to the present section, which is differently drafted in any event. So, well, the court has my submissions on the concession. Now, just dealing with the substantive point, and we've looked at the section, but it may be worth just having it to hand. So that is authorities tab A. So the argument which is raised, and for the court to note, this is at paragraphs 57 to 59 of HMRC's skeleton for the appeal, that they say that the words expenditure on the construction of a building on a site in an enterprise zone require that the building in which is to be built must be specified in the contract. The site must be specified in the contract, and the contract must mandate that expenditure be incurred on the construction of that building. And that point was, I think, made by Malone and Friend yesterday. But we said that's wrong because, as I've already sought to submit, Section 298 is satisfied if the following conditions are met. First of all, there is expenditure on the construction of building, etc. Secondly, that's within the 20-year long stop. And thirdly, it is under a contract entered into within those 10 years. And Parliament has not added any requirement that the said contract must specify any of the matters for which HMRC contend. Now, Malone and Friend accepted yesterday, as I understood it, that it would be permissible, even on his case, as he put it, to add an extra story to a building or to deal with defective drains or various other examples that he gave. But in my submission, there is no warrant within the section for setting a demarcation between, as it were, acceptable and unacceptable variations, other than the principles of the law of contract which we have looked at this morning.
I mean, how far do you take that? Suppose there's a contract under which the parties agree that when the employer gives a notice, the contractor will be asked to build an industrial building in Atterfield in Sheffield, or in a site in Tyrone Way, or somewhere in Liverpool, or Manchester and Salford Docks, or all the other, any one of 10 or 15 enterprise zones, unspecified. You say that's enough. That's good enough.
Well, it's a little, if I may say so, it's a little bit like the example that my Lord Justice Newey put yesterday, which is if you have a contract for the sale of goods, can that be then varied and amended so as to satisfy this section? So in my submission, what we have here is a building contract for the construction of an industrial building on a site in an enterprise zone, a golden contract. And the question is whether, in the events which have happened, the works which have actually been carried out are carried out within the purview of that contract or otherwise. And if they are carried out within the purview of that contract, they are, in my submission, incurred under a contract entered into within 10 years. But the difficult, in my submission, the difficulty with HMRC's position is, A, none of the specificity which they contend for has any warrant in the section. In other words, that the building must be specified, the site must be specified, etc., etc. Nor do they explain where the limit is between contracts which do or don't comply, subject to the Morrison-Barron point. And the court may recall that you were taken to the explanatory notes which gave rise to this legislation in the first instance. I don't think we need to turn them up, but the historical genesis is that Sir Geoffrey Howe, then Shadow Chancellor, made a speech in Docklands in 1978 saying what a marvellous thing enterprise zones would be in so-called deprived areas. And the purpose, clearly, as the Upper Tribunal rightly found, the purpose of this legislation is to encourage the economic growth in deprived areas by giving incentives to build industrial buildings which will then create wealth in those areas. And in my submission, given that you have a 20-year time limit, and given the fact that technology is obviously marching on, it would be a strange thing if developers and contractors were held to the scope of work which had been envisaged in year one. I mean, bear in mind that in 1980 we were in the world of typewriters, no internet, no email, no fax machines, etc., etc. And things changed a great deal in the following 20 years. And the other point in relation to my Lord's question is that, of course, Parliament must have been taken to have known that building contracts are often varied substantially, either by change orders under their express provisions or by deeds of variation or similar documents. So that's what we say about section 29H. And I come finally to clause 12. and just by way of preface, we have recently received a supplementary skeleton from HMRC on this point, and I was intending to await how those points were developed by my own friend and then to deal with those by way of reply. So this is effectively my
I'm not immediately aware of having that.
Ah, this is the 16th of September, I think.
Is that in the bundle somewhere?
I'm not sure it is.
Let's see if I've got it loose.
Yeah.
Not having had a pre-hearing reading list, we had to rather make our own way through these documents. And if there is a supplementary skeleton, I don't claim to have read it.
Ah, well, my lord, if nothing else, that vindicates my intention, my strategy of dealing with it by way of reply.
Are there more than 2 skeleton arguments from each side? Because I can certainly remember reading 2 skeleton arguments from each side.
Yeah, there are certainly 2 skeleton arguments.
Yeah, there's one for HMRC's appeal and one for your appeal.
Indeed,
Those
yes.
are the only 2 I'm conscious of having read.
The third one, which obviously hasn't got through, but I was told was sent to the court, was simply a reply to the respondent's notice point, because we obviously hadn't dealt with that in our.
I'm not conscious of either having it or having read it.
No, I don't think it matters because it's really just developing the points
All
that
right.
are below, essentially.
Well, there we are. My lords, we can put away authorities bundle A, and if we go back to the core bundle, the judgment tab 9. Page 217. So you've all read this, and you'll see that paragraph 75 to 80 they deal with and they reject our clause 12 argument, and we challenge that by our respondent's notice, and we essentially put before you the same arguments as we put before the.
You say there's no limit on the nature or scope of the changes.
Well, my lord, I'm not.
Is that really what you're saying?
I'm not sure I need to go that far. Our submission is that what was in fact instructed
Yeah, I understand that.
fell within clause 12.
I would find no limit quite difficult to accept. I mean, it would be odd, I would have thought, if you could have said, by way of an instruction under clause 12, well, we've decided not to build an industrial building in Tyneside. We'd rather have you design and build a nuclear power station in Suffolk.
Yes, but my lord, I don't think we need to set it up. But in my submission, the answer to that is the decision of the Court of Appeal in the Blue Circle case, and essentially the test is if an instruction is given purportedly under a clause like clause 12, is the contractor obliged to comply with it, or is the contractor entitled to say no, that's not something you're entitled to instruct under the contract? So that's the dividing line, but it is nonetheless a very broad power. So
And one might have thought that in a design and build contract, the power is a bit narrower, because the contractor's now got to design the thing as well.
yes, well he has of course got a right of reasonable objection, which we'll get
I
to.
thought that had been removed.
Only in part. Yeah. Now, so it I realise you looked at most of these yesterday, but it might be convenient just to remind ourselves of the key contractual provisions. So that's in core supplementary bundle at, first of all, at tab 2. So page 39, Article 1, he's got to complete the design and carry out and complete the construction of the works, and he's entitled to be paid the contract sum or such other sum as shall become payable hereunder at the time in the matter and as specified in the conditions. And the conditions are the JCT conditions. Then at page 43, the employer's requirements are simply the documents referred to in the appendix, setting out the requirements of the employer in relation to the relevant works option, and works are defined at page 45 as the design, construction and commissioning the employer wishes to obtain for the works option stated in the notice to proceed, which shall either be works option 1, etc. And then these words at the end, and any changes made to these works in accordance with this contract. So the definition of works contemplates that the works may be changed. So, as you know, as a headline proposition, the golden contract contemplates that when it is entered into, the contractor is going to do one of 6 works options, the requirements of which are set out in employer's requirements, that the developer is going to pay the contract sum or such sum as becomes payable in accordance with the contract, and the developer is obliged to specify in the notice to proceed which works option it wants to have. Now, we've just looked at the employer's requirements for works option 1, and they describe, as we have seen, both at a general level, but then in much more detail, exactly what is required in relation to those buildings on that site. Now then, clause 12, which is at tab 1, page 14, so clause 12.1 has not been amended. This is a standard JCT term, and just picking up my Lord Justice Lewison's point at clause 12.2.1. So you need to have a finger in there and then a finger in at page 51. I'll come back to clause 12.1 in a minute, but on the objection point, 12.2.1 stands subject to the fact that the words and to the contractor's right of reasonable objection set out in clause 4.1.1 are deleted. So, as amended, it reads, the employer may, subject to the proviso hereto and to clause 12.2.2, which I don't think is relevant, issue instructions affecting a change. No change shall vitiate the contract, provided that the employer may not effect a change which is or which makes necessary an alteration or modification in the design of the works without the consent of the contractor, which consent shall not be unreasonably delayed or withheld. So that's the design point. And then going back to
so they can object to the design of the works being changed if they by reasonably withholding their consent. But on your construction, they can't object to a whole-scale change in the nature and of the works that are to be undertaken. It doesn't make a lot of commercial sense to me.
Well, this is not as this particular bit is not, as it were, a difficult issue of construction, because that's what the parties have agreed. I mean, it's all a little artificial, of course, because the parties are sister companies or brother companies within the same organisation.
I can't see why that makes the slightest bit of difference with respect as to whether or not the contractor can reasonably object or not. On your construction, the contractor can object reasonably to a change in the design, but not to a whole-scale change in what's put, what he has to do, and that seems to me to be a little daft.
Well,
as a matter of construction of the contract, whereas on the tribunal's construction of the contract, it all makes complete sense. You can modify. There is a right of reasonable objection to design, but you can make modifications, but only to that option which you have selected and identified.
well, lady, I'm going to come to the Upper Tribunal's decision in a moment, but just on the commerciality of it, if this is what the parties have agreed, and I agree it's of marginal relevance, if any, that the parties are effectively closely related, if this is what the parties agreed, this is what they've agreed. And that doesn't really inform the breadth of the power to issue a change under clause 1211. And coming to that power, the employer can instruct a change in the employer's requirements, which makes necessary the alteration or modification of the design, quality or quantity of the works, including the addition, omission or substitution of any work. So those are broad words. Now, what then happens if there is such an instruction? And this is, I think, important. Is that
so? Just pause a moment.
yeah.
The employer could give notice to proceed, saying I've selected works option 1, and having given that notice to proceed, the employer could then change its mind, say, well, we'll have works option 6 instead, and issue an employer's modification of the employer's requirements of work option 1 so as to make it exactly the same as work option 6. Is that right?
Yes.
Doesn't seem much point then in having the developer choose one of the specified work options. What's the point of that?
Well, your lordship, with respect, is putting an extreme case, but my submission is that he's entitled, the employer is entitled to go into the employer's requirements,
yeah,
and change them as much as is permitted by clause 12.
Yes, but that begs the question as to what clause 12 actually permits it to do. My Lord's question is testing that by pointing out the extreme consequences if you're right.
Well, I see that, maybe, but if you can make, as we submit you can make, a change in the employer's requirements, there's no limit in the contract, which, in the words of the clause, makes necessary the alteration or modification of the design, quality or quantity of the works, and the works are those which are called up by the employer's requirements.
That becomes a circular argument.
Well, it's
totally circular argument because you've got to define the works first and then decide whether or not the employer's requirements amount to an alteration or modification of the design, quality or quantity of those works.
Well, with respect, we know what the works are because they're a defined term.
Yes, that's the point. The question is, can you change the defined term? Now, at the moment, all you've pointed to is something which says that the works may be changed in accordance with the contract, which begs the question too, because the question is, which bits of the contract entitle you to change them?
Yes, I'm getting to that, but if the court would just bear with me to this extent, what I was going to say was that once an instruction is given, if you then go to tab 2, page 51. There is an inserted clause 12.3a, which provides a procedure effectively for the contractor to say all of the compensation which he is entitled to as a result of the instruction. That's clause 12.3a1 on page 51. Then at 12.3a2, the parties are to endeavour to agree, and 12.3a3, if they can't reach agreement, then the employer may nevertheless instruct the contractor, in which case the provisions of clauses 12, 25 and 26 as appropriate shall apply. And now I'm sorry to keep darting about, but if you then go back to clause 12.5 on page 16, if there isn't an agreement, the valuation of additional or substituted work, this is 12.5.1, shall be consistent with the values of work of a similar character set out in the contract sum analysis, making allowances for change in conditions, etc. Where there is no work of a similar character, a fair valuation shall be made. Again, a very standard term in building contracts.
Sorry, just clear this up, would you? Clause 12.5 is headed Alternative B, and Clause 12.4 is Alternative A. There presumably is something in the contract which tells you which of these two alternatives apply.
My lord, I think there is, but I was actually reading from that's clause 12.4. I was actually reading from clause 12.5 on page 16 of the bundle.
Oh, I see. Alternative B is an alternative to what then?
That's an alternative to it's an alternative to alternative A, which you found on page 15.
Oh, I see. I'm so sorry. I've misunderstood. Yeah. Yes. So the upshot is that the contractor can't refuse because the employers can instruct under 12.3a, even if they can't agree on anything. Is that right?
Yes.
You accepted, I think, in answer to a question from me that you're not any longer saying there are no limits on what the employer can do under clause 12. I gave you the example of nuclear power station instead of an industrial building. I think you accepted that would be outside the scope of the power. I think we had a little bit more difficulty with can you change works option 1 into works option 6 by an employer's instruction. I'm not quite sure what your position was in relation to that. But I think it's implicit in what you are now arguing that you accept that there are some limits on the clause 12 power. So the question then becomes, well, what are those limits and where are they to be found?
Yes. Well, my lord, with respect, I'm not sure that there has been that I've changed my position, because in our skeleton argument we refer to the Blue Circle case, and the burden of the submission was is that the question is the contractor entitled to refuse to do that which is instructed?
Well, I think you've just been showing us clauses which suggest that he's not.
Well, he is entitled to refuse to do it if it is out with the powers.
Well, then we're going round in a circle.
Well, yes, but then the question becomes: Does clause 12.1 empower the instructions which were actually given? Yeah. So clearly, one can respectfully conjure extreme examples of a contract for the construction of a garden shed, which is thought to be amended, thought to be varied under an express power to a contract for a nuclear power station, etc., etc. But we say that's not this case.
Well, isn't the key question whether 12.1 allows an instruction to be given to change the designation of the works with a capital W? Either it does or it doesn't. Tribunal said it doesn't, gave very clear reasons for reaching that decision, and they don't have the far-sweeping consequences that have been put to you with the extreme examples of swapping option 6 for option 1 and so on and so forth.
Yes, I agree with you. So, if we can go back to clause 12.1 on page 14. So what the employer is entitled to do is to make a change in the employer's requirements. Well, we know what they are. They are defined as the document setting out the requirements of the employer in relation to the relevant works option, which makes necessary the alteration or modification of the design, etc., of the works. And we know what that is, which are the design, etc., which are within works option 1, etc., referred to in the employer's requirements, and any changes made in accordance with the contract. And in my submission, the Upper Tribunal was wrong. We can just, the ladies referred me more than once to their decision, so can we just go back to that? Paragraph, page 218, paragraph 80.
Do you not want to start with 76?
Right, I get it. I
I mean, don't let me take you out of your course, but
well, then I'd like to do with paragraph 80 first, if I may. I appreciate I am going to get to the other paragraphs, but the Upper Tribunal described my submission, and I don't think that they were intended to be complimentary, as ingenious. The submission being that where works option 1, for example, refers to a particular type of manufacturing facility, that you can change those words to replace it with a reference to a data centre and accompanying specifications. Lady, I abide by, sorry, my lords and my lady, I abide by that submission, because in my submission the employer's requirements are a document. They can be changed under clause 12.1.1 if that change makes necessary an alteration in the works, which are also a defined term, including the addition, omission or substitution of any work, then clause 12.1 is engaged.
Yeah.
And the Upper Tribunal rejected that submission by saying this: those words exist in our judgment in order to identify the works option to which the employer's requirements related that are not operative parts of the employer's requirements for that works option. Now, with respect, that can't be right, because the words, the construction of an 8-inch fab semiconductor manufacturing facility, are as much part of the document as any other words. Indeed, they are on one view, the most important part of the document. So, in our submission, the employer's requirements set out the requirements of the employer in relation to the relevant works option, and the change orders instructed a change in the employer's requirement, i.e. the document which sets out the requirement in relation to the relevant works option. The reason I went to paragraph 80 first is in my submission, if the Upper Tribunal are wrong about that and is open to the employer to issue an instruction which changes the wording of the document, which then results in a change to the capital W works, and then requires the addition, omission or substitution of any work, then that point is decisive.
It's a very convoluted way for contracting parties to achieve a very simple objective, which is that you can make a change to the works. It would have been so much easier, rather than saying you can change a document which changes the definition, to say simply you can also make a change to the works, but nobody did that. Which rather suggests that that wasn't what they had in mind in clause 12.1.
Well, Milady, with respect, I'm not sure that's right. Clause 12, as I say, is a standard variation provision, yeah. And where you've got employers' requirements, that is the way that you get at the change. I agree. Other procedures could have been adopted, but that is the procedure that these parties fastened upon.
Just going to looking at what the works are.
Yes.
We're back on page 45 of the supplementary part. It's the design, construction, and commissioning the employer wishes to obtain for the works option stated in the notice to proceed, and it's either 1 or 2 or 3 or 4 or 5 or 6. You go then to what works option 1 is. Works option 1 is a design, construction, and commissioning work comprising an industrial unit to accommodate the manufacture of an 8-inch board on site C. Can that be changed under clause 12?
Well, my lord, insofar as is the case that description also appears in the employer's requirements, then yes. There's no power under clause 12 to change the terms of the contract, obviously. But there is, in my estimation, power to go into the employer's requirements, at the relevant employer's requirements, and rewrite them, and then issue an instruction on that basis.
So the employer could say, I don't want this built in Tyneside, I now want it built in Sheffield.
Well, if I may say so, I appreciate that one can look at a number of extreme examples, but in my submission, we are principally interested here in the actual change which was made, which is much less.
Well, no, we're not, with respect. We're at the moment we're looking at the construction of the contract.
Yes.
To see whether, as a matter of contractual interpretation, there are any limits on the clause 12 power, and if so, what they are.
Yes.
And the Upper Tribunal said, yes, there are limits, and we will now construe the contract to see what those limits are. Now, I understand you to accept that there are limits, but I'm not sure that I yet understand what you say the limits are, except you say that, well, it doesn't permit an extreme case, but then how do you judge whether a case is or isn't extreme?
Well, but Lord, that's inherent in the proposition that there are limits. But the contractual answer in my submission is that the employer can only issue an instruction through what the lady refers to as the convoluted mechanism of clause 12.1.
Yeah, well, I think everybody agrees that. The question is, what does clause 12.1 permit?
Yes, well, I'm in danger of with respect to repeating myself because I submit it does, as per rather contrary to paragraph 80 of the judgment, it does permit substantive changes to the employer's requirements.
Depending on what's actually put in the document. So if the document itself happened to mention Site C, then you could change it from Site C to Site A. But if it didn't, you couldn't.
Well, my lady, I'm not sure that's necessarily right.
No, well, there you are. So we even that proposition doesn't work as a limit.
Well, again, maybe I don't want to repeat myself, but my submission is where the Upper Tribunal went wrong, paragraph 80, was to distinguish, as it were, within the employer's requirements between operative and descriptive provisions. And in my submission, there's no such distinction. So, coming back then to the three the three reasons which the Upper Tribunal gave for rejecting our case. The first is at paragraph 77. They say that the clause distinguishes between the works and the employer's requirements and contemplates changes being made in the employer's requirements, not the works. In my submission, that is circular because 12.1 allows you to make a change in the employer's requirements, which then changes the works, in effect. The works are themselves those which are referred to in the employer's requirements, and for the reasons I've already submitted, the employer's requirements can be changed.
Yeah.
Then at paragraph 78, they say the respective definition of the works in the employer's requirements demonstrate that the latter exist as part of and as subordinate to the former. With respect, I don't really understand that because the employer's requirements are not in some way inferior to the works. They define the works, and in any event, the employer's requirements can either be changed as we submit or they cannot.
Yeah.
And then as regards paragraph 79, they say that until a notice to proceed is given, there are no works in play. Well, that's right, but once the works are in play, the works may be changed.
Yeah, that's really a timing point, isn't it?
Yeah. So, my lords and my lady, as I say, I'm going to await my known friend's development of his submissions in answer. But subject to that, those are my submissions. I just had this observation that one or two questions have been asked. I don't know whether it will be possible for me to. I don't mean on the substantive arguments, in terms of missing documents and so on.
All right, well, you can give us an answer later on.
2 o'clock or something.
Yeah. Right, where do we go from here? Mr. Hewitt, you to reply on your appeal and the respondent's notice point.
Yes. Can I take this in the same order as I took the original submissions, starting with the statutory provision? I'd first like to deal with the so-called concession and the significance of it. your lordship is obviously right that it's a matter of the court anyway what the law is. But can I just make clear what was agreed between the parties, which you will have seen from the email, which was simply this, that where there's a reference to contract in section 298, that doesn't have any special meaning outside the law of contract. So whether there was a contract formed, whether it was varied or rescinded or a new contract, are all to be decided on the basis of common law principles of contract. What it wasn't was a concession that as to what 298 means, in the sense of what are the requirements of the contract within the 10-year period. And I won't go into this now, but you can see from the annex which we provided to our skeleton, which is our skeleton on our appeal, we set out various passages in the transcript where the tribunal were clearly aware that this was a point that was being argued by the revenue at that stage. I think Judge Richards expresses it quite well as to you'll see in the transcript versions. The question is how you construe section 298. And with respect to my little friend, it's no answer to your lordship's questions about what is the scope of section 298, what kind of contracts would do, to say that, well, the contract in the present case was a construction contract. Because, of course, the point is you have to decide what the construction of the statute is by testing the two propositions. Can it be any contract, which is what my learned friend seems to be saying, or is it limited in the way the revenue say? And as I say, there's no answer to that, to say, well, in this particular case, in fact, the golden contract was a construction contract, as it happens. So can I just take you then to section 298. And we have to start with the opening words. As your lordship pointed out, the time limit for expenditure on the construction of a building on a site in an enterprise zone. So the basic position is that it has to be expenditure on the construction of a building on a site in an enterprise zone. And that can only be within the first 10-year period when there is an enterprise zone. Because otherwise it wouldn't be in an enterprise zone after the end of the 10-year period. That is modified by B, which brings in a contract entered into within 10 years. That expenditure, but it's still the same, the expenditure on the construction of a building on a site in an enterprise zone, the contract was entered into within the 10 years. So one has to be able to identify when the contract was entered into, the expenditure on the construction and the building, and the site, and that is in an enterprise zone at the time. And in fact, thinking about this more deeply, that actually comes to the same as I think the draftsman may have achieved what he set out to do. That actually is saying the same thing as the previous provision, although in different words. If you remember, the previous provision referred to a contract. At the time of the contract, it had to be a building in an enterprise zone within the 10-year period.
B contemplates that you haven't yet built it within the 10 years.
You haven't built it,
but there is a contract to build it.
A contract to build, exactly. It's a putative. When it talks about a building, it means a putative building.
Yes.
Obviously, on a site in an enterprise zone. So that's what we're talking about. It's a contract to build
something.
To build a building on a site in an enterprise zone, the expenditure of which is what you are claiming. That's the expenditure incurred. Because the expenditure in B is the same expenditure that is in the opening words. It's referring to the expenditure, not just any expenditure. It could have said if expenditure is incurred. That would have been different. That would
I'm not
have
quite
meant-
sure I follow stress on the definite article.
Well, because it's
The expenditure. That
B is referring to the same is referring to the expenditure that is referred to in 1, which is the expenditure for which relief has been claimed.
Yes.
Expenditure.
Why does that mean you've got to identify the building at the date of the contract?
Well, you have to identify the contract at the time of the contract, which is within the 10-year period. You have to be able to identify the expenditure and the building on which it is being spent potentially, and the site in the enterprise zone, because it has to be a particular building being built on a particular site in an enterprise zone.
Well, this is no doubt a hypothetical question, not least because I don't know what the relaxation of the planning position was. But suppose you have a contract, and what the developer wants to do is he wants to build a hotel, which qualifies.
Yep.
But if he can't get permission for that, then he'll build an industrial building instead, which he knows he will get permission for. That's no good, you say, because there are alternatives.
Well, and you're positing that he enters into a contract.
Yeah, to build one of the
other.
two, depending on whether he gets
On the same
planning
site.
On the same site. Let's suppose.
Yes. I can see the problem, but both would qualify.
Yeah,
So.
but they'd be quite different expenditures.
Yes, I suppose. Yeah.
Yeah,
But it still would have been
building a hotel or an industrial shed.
It still would have been a contract that, if it was one or the other, was binding during the 10-year period to build that building. And when you read industrial building, you can read in hotel.
Yeah.
So it doesn't. I don't think it matters that it was one or the other.
Because I think what you were saying was you've got to identify the building in the contract. So I'm putting to you.
Yes, but there could be two buildings. Oh, I'm not necessarily limiting it.
Yeah.
If there was an alternative in the contract.
Yeah.
To the two, which is why I said yesterday, if they chose one of the options in the particular contract, that might
one of the works options. Yeah.
the works options, that would be all right.
Yeah.
Because that is in place within the 10-year period.
Yes, I follow.
Yeah.
So you can have alternatives in the contract, but what you can't do is to dream up an alternative which isn't in the contract.
Subsequently to the 10-year period.
After the 10-year period.
Yes, exactly. Even if it is possible for that to be under the same contract, and of course that's a separate question, but even if that is possible.
Right.
And this does accord with the policy of the EZA enterprise zones generally, which is not to allow economic activity wells in the future, but is to bring forward economic activity into these zones within the 10 years. That's why they're time limited. If they weren't time limited, then you might find that there wasn't so much activity initially. People could say, well, we could do it any time. We'll do it 5 years, 10 years, 20 years time. The purpose of the time limited provisions is that these places need regeneration now, or at least soon. It's not something you want to wait 20 years for. We would submit, and that's why all these things are limited to a 10-year period.
Yeah.
But if they've entered into the contract within the 10 years, then that's regarded as sufficient because they are committed and the economic activity is going to take place.
If they've entered into the contract and the contract the contract is a contract on any view which provides for the building of an industrial building on the site. And why does it matter whether the building is a factory or some other building? Or whether one can be substituted for the other after the event? Why does that subvert the policy?
Well, if you do enter into a contract to build something and then later on change your mind and then agree to build something completely different,
something else, but it's equally an industrial building and it's on the site in the enterprise zone. At the moment, I'm struggling with why that somehow subverts Parliament's intention.
Well, it leaves it open to the parties to enter into a contract and then wait for long periods and then decide, oh, we'll change it now and we'll decide what we're actually wanting to build when they build that. That would not what Parliament was intending, Section 298. I agree, it's limited, but then these are quite generous allowances, you remember, like 100% allowances. But the problem is that the alternative, if you're looking at this as a matter of statutory construction, it's very difficult to see what other limitations you could place on this.
Well, there aren't any other than the fact that it's got to be a site in the enterprise zone and it's got to be an industrial building or a qualifying building like a hotel.
Yes, but if you going back to my lady's question, if you allow the contract to be for something else, I don't see how you could limit that. I understand your point that if it was a contract for an industrial building and then you were agreeing years later to vary it to something else, you might say, well, what's the mischief? But if the provision would equally allow on that construction you to agree for to be a contract for anything.
Well, you could turn it the other way around. You enter into a contract to build houses in an enterprise zone, and then after the 10 years are up, you change your mind and you say, well, I'll have an industrial building and get the allowances now.
Yes. Yes, but it's not even clear on the taxpayers, the alternative construction, whether the contract has to be for something in the enterprise zone. Because the way that my learned friend read it, he was simply saying, well, you've incurred expenditure, in fact, on a building, an enterprise zone. It's within the 20-year period. There was a contract within the 10-year period under which that is now being built. I can't see logically why, if that's right, you couldn't start with a contract to build a building outside the enterprise zone.
And then vary it to make the building within the enterprise.
Exactly, yes. And I imagine, Milan, you could say, well, you could provide something specific in the contract that allows that variation. You could provide a clause 12 that's much wider than the actual clause 12, and to make it clear that you could vary it to build something in an enterprise zone or wherever. So I think that's probably the answer to the construction problem, lady. As far as the judicial review is concerned, my learned friends seem to suggest that somehow, if he'd understood this point, the UT hearing that they would launch some judicial review on the basis that the revenue had undertaken previously that you could do this. But if we looked at the
I thought that was your argument that the works were carried out under the SDA rather than the JCT.
Well, maybe it was that. Yeah.
I think that was that was the JR point.
That was a GR point. Yes. Yeah. I mean, maybe I can just make this point generally now. It's clear when you look at what I showed you earlier that no one was contemplating at that point variations or changes to the contract. There was no mention of that anywhere. Indeed, the only change that was mentioned was the possibility of changing, if you remember, the contract sum so it would be paid up front rather than in stages. And Mr. Watson had a concern that might cause it to be a new contract. And the revenue said probably not, but would depend if the case depends on its own facts. So, so there was no suggestion. Sorry. Yes, this is about upfront payments. Yeah. Yes, that's exactly the passage I was talking about. It says as a moot point, each case will turn on its own facts. That's what the revenue said.
Yeah.
How it works. You can hardly judicially review them. We're saying that they said every case depends on facts. They didn't say you'll always get relief. You vary the contract. The very opposite, they said. Every case will turn on its own facts as regards variations, which is obviously all they could say. They couldn't possibly know what kind of variations people were going to enter into.
Yeah.
So that probably completes section 298 right there.
Right, was that a convenient moment to break?
Yes.
2 o'clock. If you can get instructions on releasing the certain argument between now and then, that would be helpful.